Well, who says so? Hi, I'm Sam Hayes. I'm a risk management focused TC, and I want to talk to you today about the different types of disclosure requirements that we have on transactions. As always, verify everything with the broker of record and the local government where you are working on your file. There are many different types of disclosures. We have statutory, contractual, point of sale, risk management, and then broker required. We have the usage of, well, it's required by law. Not always. What we need to know is the difference between these disclosures, which side of the file, who needs them, why, and whether or not they actually apply, or it's just something that's on a checkoff list that everybody's just dotting their I's and crossing their T's about. Statutory. It's required by law, but is it? Statutory disclosures aren't always required on every single property. Typically, statutory disclosures are for 1 to 4 units where they have the TDS, lead-based paint, natural hazards, seller property questionnaire. Those are actually per civil code because they are disclosing information required by the civil code. Natural hazard itself is not required, however, the information contained inside of it is. Same as the agent's visual is actually not statutory required, but the action of doing the agent's visual is. So the AVID was created to help document this for proof that the agent did their required duty. There's also statewide different compliance issues that you have to be aware of too, depending on what the age of the property is, where you're located, and how it affects. So saying it's required by law, well, you need to know, is it really? Or are you just demanding something because you'd like it in your file? Which is not a problem, but let's get it communicated first. My broker requires it. Okay, that's awesome. But did you put it in the contract? Some brokerages have been advised through their different legal or their own experience for risk that they want certain disclosures on all files in their brokerage. That's great. However, if it is not put into the contract, it's not contractually required. And if that disclosure does not typically apply to the property based on age, location, or if it falls within exemptions due to TDS exempt, if it's an REO, probate, or other type of sale, it may not have to be produced. So communicating what your broker requires in the beginning of the transaction, be it included with your offer or put it in your offer, it's really important. There are actually 2 sections that you can do this in the contract. There's an area for addenda and there's also an area for advisories. What you want to do is go ahead and know that anything you put there, though, could be required by a lender. Point of sale. So different areas require items for points of sale. An example is here in City of San Diego, any property that is transferred, doesn't matter, it's not exempt at all, has a point of sale requirement. So that even means a trust sale does have a water cert requirement. Same issues come up in Palm Springs, LA, and other counties. Chicago Title has a great list of them that are online that I linked in the description there. Otherwise, what you can do is also ask your local escrow officer and double check with the brokerage and any local governments. You want to make sure you're finding out what is required to sell this property in that jurisdiction. Then there are disclosures that are just for risk management. And these were created from lawsuits. The whole reason we have all these disclosures and all these paragraphs is something happened where there was a civil situation, a legal situation, and from that, they went ahead and created a disclosure so it wouldn't happen again. They're also created to help prevent when we have new information and regulations coming. An example of this is the fire home hardening and defensible space. We have different levels of requirements that'll be coming. Also, accidents happen. If a situation's come up that your brokerage is aware of or you know something's happened, it's better to always share and mitigate the risk and say, this is what has happened with this property. There is a potential liability. If there's ever any question, you always want to disclose. The whole reason for the disclosures is to convey information about the history of the property to the new buyer. If you know you need something, put it in the contract. If you have an affiliated business, your brokerage has proprietary disclosures that they've created due to their association with the legal counsel or whatever, just go ahead and include them with the offer. It's easier, it gets them out there, and other brokerages just don't know what your broker may require specifically for your files. When in doubt, provide the document. Truly, there is no reason for not disclosing information when requested to a buyer. The disclosures are created as protection pieces. They are not marketing pieces. They're not there to make the property look great. It's about the good, bad, the ugly. It's the history, and it's an informational transfer to the buyer so they're aware of what they're purchasing. Unless you can support showing why something's exempt from any documentation from CAR or citing legal, there's no reason not to provide the disclosures. But again, either way, provide something to document your file for the reasons behind why you provided the disclosure or did not provide the disclosure. Documentation is always key in the situation. Do you have any questions? I'd love to talk about this anytime I can. I will talk about forms and how to do file compliance till I'm blue in the face. I look forward to hearing from you. But again, always verify everything with the broker of record, but let me know how I can help. My name is Sam Hayes from One Stop Transaction Services. You can reach me at 619 993 7264. Thanks so much.